Ladies and gentlemen, welcome to another episode of Legally Speaking. I'm your host, Oves Anver. The Indus Waters Treaty has been in the news again, and again, not for very good reasons. India has rejected, once again, another Permanent Court of Arbitration's decision. The previous one that we had last year in August reiterated India's obligations under the Indus Waters Treaty and said that it couldn't really hold the treaty in abeyance. More recently, the Permanent Court of Arbitration held that the pondage limits, the amount of water that India could store, were also limited by the treaty and that it had to abide by those obligations. Both of these were rejected by the Ministry of External Affairs, the Indian ministry. And it stated essentially that this was an international charade that Pakistan was playing. Pakistan was manipulating international institutions that apparently are neutral, the Permanent Court of Arbitration, highly respected globally. Having said that, the situation is escalating. India has now made attempts to expand efforts or divert water away from that flows into Pakistan. Again, in clear violation of the Indus Waters Treaty. It feels it's justified because it has held this treaty in abeyance. Pakistan and the international community apparently finds that there's no such justification under the treaty or under international law for India to do so. India is using this as a bargaining chip, perhaps. That seems to be the case. To discuss this in more detail, I have with me Mr. Ahmed Bilal Sufi. Mr. Sufi is an advocate of the Supreme Court and Pakistan's foremost expert on international law. Thank you so much for joining us, sir.
Pleasure is mine.
Thank you, Ji. Sir, I wanted to begin by asking that after the Pahalgam attacks, India used that as a basis to hold in abeyance the Indus Waters Treaty. Now, this is a treaty that doesn't really have such a mechanism for holding something in abeyance. How do you understand this under, from the perspective of international law? Is this something that is doable? Is this something that can be really implemented by India or the actions that have followed suit?
I don't think so. There is any such thing as holding in abeyance a treaty and using it as a pretext not to implement the obligations under the treaty by any state. In fact, this term is extraneous. It is a stranger to the entire jurisprudence of law of treaties.
I see.
You either use the term termination or suspension, but you do not have a provision under international law of treaties to talk about holding in abeyance. It doesn't mean anything. It means you are creating a legal mask or a general mask of a certain grammatical term.
Absolutely.
To mask your political objectives of terminating a treaty unilaterally, which you don't have otherwise directly. So you're trying to achieve indirectly what you cannot do directly.
I see.
So holding in abeyance is something that no one has accepted in the world so far. I have looked at statements coming out of EU countries, US, other groups. No country has supported or even endorsed this idea of holding in abeyance because everyone knows it can completely create an adverse impact on the good standing of the rule-based order that we follow as the countries.
Absolutely. The principle of pacta sunt servanda, that, once you've gotten into an agreement, a contract, you must abide by its terms and respect that.
And as you said, it was in response to Pahalgam.
Mm-hmm.
So they are saying, or the case that they are trying to build is that as a countermeasure to an act of terrorism, we can suspend a treaty. Now that's a dangerous precedent.
Almost punitive.
No law allows it. In order to counter terrorism, there are measures in place. So what India could have done is to use their mutual legal assistance provision in the criminal court and demand from Pakistan under Pakistan's Mutual Legal Assistance Act that we suspect some people are associated with Pakistan who are involved and we undertake investigation. That would have been a more proper course. That would have been what we call, and you remember we have discussed this,
Absolutely.
The lawfare course. They have chosen the warfare course, and as a consequence of that, they have inflicted on themselves a very serious embarrassment as well.
Absolutely. So recently we had the Permanent Court of Arbitration's decision. This was again, we in fact had two in a row. One was supplemental, which basically, August last year we had them say that India is under obligations to abide by the Indus Waters Treaty, let the water flow. Then more recently we had, the Indian Ministry of External Affairs say that, reject that and say that, this is a charade at Pakistan's behest. How do you feel India really trying to portray this that we are manipulating international institutions for our own benefit, whereas, these are neutral institutions, especially the Permanent Court of Arbitration or whatever mechanism they've had.
No, I agree with you that Permanent Court of Arbitration is one of the most widely respected judicial forums in the history. Apart from International Court of Justice, as people talk about, the Permanent Court of Arbitration has been there for decades.
Absolutely.
And it is so well regarded that no one even thinks ever to disregard an order, injunctive order, or an award passed by such an authentic forum. And if you do that, you completely destroy your credentials as a responsible state. And that is what India is doing. So if it is seeking a claim from a permanent seat in Security Council, that claim, that effort, that campaign stands destroyed by such acts that you deny, you decline to accept, and decline to have any regard to an award which has been handed down by a most authentic, most respected global judicial forum.
So, do you feel that given the particular circumstances we're in, that there is, almost a breakdown of the international order, that within this particular confines and in this context, India playing this particular role, do you think that it's because of this, and India's actions are merely a symptom, or do you think that it's contributing to it, given how enormous a role India plays in global affairs?
I think I'll divide it into two segments.
Okay.
Segment one is the domestic audience of India.
I see.
To me, it is a fulfillment of the election promises that BJP has been saying or extending to its voters and its followers.
Mm-hmm.
They are fulfilling that almost meticulously. Whether you look at Article 370, whether you look at the way they're trying to completely swallow occupied territories of Kashmir and so on. And now you have this, something that they have stated openly, and they want to go on with it.
Mm-hmm.
They also said they will strike hard against Pakistan in case of terrorism, so they have declared countermeasures. They did that in 2019. They tried to do this in Sandur as well. So their use of force or their use of countermeasures is linked with their domestic politics.
I see.
Now, let's see what is happening in the rest of the world. Yes, there is a threat to the rule-based order, but to me, it is still there. The rule book of international law has not vanished. And the rule book of international law, you and I know,
Absolutely,
comprises of not one treaty, one text or two texts or three or four texts, but a stack of agreements that countries have executed amongst each
Tens
other.
of thousands.
Tens and thousands and perhaps millions. In fact, it is difficult to count.
Absolutely.
You remember in one of the work projects, we were trying to get
Estimate.
near to an approximate figure, and we couldn't because they were in millions.
Absolutely.
And even exchange of correspondence has been treated as creating a
treaties, as
legal
agreements.
obligation. So, with that rule book, if I may say, use a general term,
Absolutely.
for international law stack of treaties is massive, huge. It's controlling interstate relation, trade, commerce, and a host of other issues and matters. So to assume that it has been demolished simply because Mr. Trump decided to attack Iran or Israel decided to attack Iran, in fact, it is that very rule book against which this conduct has been measured and declared unlawful. And that is why no one is standing with such actions which are completely in disregard of the rule book. So just the same way, what India is doing to Indus Waters Treaty, it is walking away from the rule book. The rule book is written in various forms and shapes. It's IWT is one subset of that rule book. The Permanent Court of Arbitration Award is a second set of that very rule book. And so on, general water law. So if you say, I don't agree, I don't want to send water to Pakistan and I'm taking a revenge for events which happened 10, 20 years ago, because what is the nature of revenge that they claim to take in respect of whom? Those people who have become far old, they are obsolete, they are struggling to fight cases in Pakistani courts against de-sealing of their properties. Sealing of their properties. They have been proscribed by Pakistan's Terrorism Act. They have been actions have been taken against them. Criminal proceedings have been taken against them. So Pakistan is both able and willing to curtail the mischief of terrorism within its territory, and it has successfully been so documented in FATF evaluations. It has been documented by CTC that yes, we have not been able to identify if Pakistan is undertaking any adventure on mainland India. relating to terrorism. There's not even a single thing, and yet they are arguing imminent attack against them. So I think this is not selling, and it is also in violation. And IWT holding in abeyance is part of this package of countermeasures against Pakistan to create and sell to their domestic audience. But as I said, international community is not buying it, and India is sidelining itself from global leadership. And that is why when their people talk about, and their experts talk about in talk shows and in articles, that why are we being alienated? Why Pakistan is taking a center stage in the regional affairs?
Absolutely.
It's simply because Pakistan is adhering to international law rule book. So whether it's FATF compliance framework, Pakistan adhered to the rule book of
Absolutely.
FATF. Whether it was counter-terrorism measures under 1373, Pakistan and all governments and all political forces were together in taking action against terrorists individually, collectively against the entities, and curbing transnational activities of the net. So Pakistan has emerged as a more responsible state.
Absolutely, absolutely. So returning to the arbitral decisions, one, the supplemental award that came in just last month in May, the Permanent Court of Arbitration handed down a supplemental award concerning the maximum pondage that India could have. And again, it made reference to the Indus Waters Treaty, and this was something that India was not wanting to be party of, and so this decision came about, which imposed again the maximum pondage levels that are enshrined in the IWT. It limited really India's own interpretation of the run-of-the-river projects that it had imposed, which was far more expensive than what was really agreed under the treaty and what was the understanding of the parties at the time it was signed. So do you think that this will have an impact on India, or is this just good to have legally on our side, but really India's actions are not going to be curtailed by a decision like this?
I think I foresee going forward a situation where Pakistan will have to consider a very strong countermeasure of some nature. So at that point in time, all this legal support documentation that Pakistan is winning over on merits from the Permanent Court,
neutral third
parties and World Bank and elsewhere will become crucial in terms of making up your mind that how far you wish to go in countermeasures. So this is continuously support being provided to Pakistan, something which is on merits again, not because Pakistan is lobbying for it. These are judicial objective forums. You can't persuade them just from a political standpoint. You have to argue your case. And this forum, credit to it, gave due process opportunities to Indian side. And throughout this process, when India announced holding in abeyance, they paused the ongoing arbitration proceeding, and they then issued notice to Indian government, inviting them to give their version as to what does this mean for the jurisdiction of this court. I mean, when they're holding in abeyance, so should this court, which is drawing its jurisdiction from the IWT, should it continue or not? So it was a great opportunity for India to come back to this court and say, sir, you better stop because we are held in abeyance and therefore you don't have any longer the jurisdiction. They chose not to enter the appearance.
I see.
And they chose to stay absent. Now that's because they were aware that they cannot defend this position.
Absolutely.
If you are confident of your position, you invariably enter appearance in that very court whose jurisdiction you are challenging. That's such a fundamental rule of procedure that every lawyer knows in civil courts, in domestic courts, and as well as international courts. If you say you don't have the jurisdiction, then the thing you should be doing is enter the appearance and say, sir, in our view, you don't have the jurisdiction. In RMI case, Republic of Marshall Island case, me and my team were advising the government, and there was a lot of debate on this, whether at the jurisdictional stage we should enter appearance or not. And eventually the consensus was we should, because unless we are there, we cannot tell the court you don't have jurisdiction.
Yes.
So it should not inadvertently or on account of missing our version come to a conclusion which could be counterproductive to us. All countries do that, and there are very few examples where countries walk out of any arbitration proceedings on a pretext of protest or whatever. And if they're doing so, then reasons are purely political.
They're not legal in any, absolutely.
Then it is very clear that you are likely to lose legally. So that is why you are walking away. So that's the first indicator that you have a weak case before that forum if you don't enter appearance in that forum.
So they're essentially saying we won't even play the game.
We want to play the game which is created by the statute and which is created by the court with itself. So then, obviously, then they examined whatever material was submitted. They even passed another procedural order asking India to submit documentation before they gave this bondage restriction framework view.
I see.
And they said, provide us the necessary document for us to assess. Again, they failed. So the order that was given was based on their interpretation, based on their experience, and the assistance that Pakistan gave to the court. And rightly so, they came to this conclusion that there's a restriction which creates now a design compulsion restriction on the Indian side.
Which I think is very critical.
Which is very critical.
Because basically, if ever there is a return to the Indus Water Treaty or a framework like that, those restrictions would now be part of that.
Those restrictions will be part of it, and even to me, they are applicable to an ongoing project they are planning right now.
I see.
Because there's a judgment given by the court.
Absolutely.
Now, if you say you don't want to accept it, that's your personal calling. But from a global standpoint, Pakistan has now a position to say, well, you can't violate this verdict, or pursuant to this verdict, the treaty implementation. Because they gave a separate view, saying that we have the jurisdiction and unilaterally declaring a treaty being held in abeyance does not deprive us of our jurisdiction, so we'll continue with the case.
Absolutely.
And again, they gave several opportunities. So if you're not coming to the court or the judicial forum, then clearly you think you don't have a case.
Absolutely. So you had mentioned, the restrictions that are now going to be imposed or on, projects that are being developed by India. After the suspension, we also saw India develop or at least try to start to develop the Chenab-Beas link tunnel. Right, and this interbasin diversion of water, which is really, against the spirit of the treaty, because only run-of-the-river projects are permitted under that. So, do you feel that this 8.7, I believe, kilometer tunnel that is being developed, it's some 2,000 crore rupee project there, so it's a pretty large project, and these are Indian rupees again. So, since the Chenab River is a western river, does this go against the spirit, and what really is India aiming to achieve through these types of maneuvers?
To me, it's a material breach of the treaty framework.
Okay, wow.
Because you are now actively diverting the water which is due to Pakistan to Beas and other networks inside India. So to me, it's a fundamental breach of a treaty basic provisions, because that is not something envisioned, creating of this kind of a project where you actively divert. You can have projects on the running water, but the diversion is nowhere so provided in the treaty. So this diversion creates that serious suspicion as to what is the purpose. And again, irony is, you don't even need to speculate what is the purpose, because the purpose is provided in a statement of objects by Amit Shah and by other people in the Indian government. Yes, we are doing it. We are doing it because you do terrorism. We are doing it because we will dry out Pakistan. And we are doing it because of whatever political reason they are saying. So they are wearing it on the sleeve. They are not even hiding the motives. I mean, as lawyers, when you look at and interpret a treaty and you look at the conduct of parties, you make an effort to infer that this is, sir, the motive. That's what we do in courts every second day. We look at the conduct, and from the conduct we develop an inference that, sir, that is the nefarious design behind him, and please note these acts that he is conducting.
Absolutely.
But in this case, we don't even need to bother to do that. They are saying it openly, overtly, and they're saying, this is our purpose, this is our declared objective. So I think, and that's where it goes beyond the treaty and IWT framework. That's where it goes in the domain of the UN Charter. That's where it is the threat to peace.
International peace and security.
Because now they are threatening stoppage of water. They are not doing it right now. So to me, this threat of stoppage of water is equivalent to threat of use of force under the UN Charter.
I see. Wow.
Because now they are using the force of the water to dry out. people in a low riparian state.
Absolutely. So in a country like Pakistan, 80% of our irrigation is dependent on Indus Waters, right? This is not something that can be taken lightly domestically. So I just wanted to, double down on this point. This is not the only project that they are working on. There's also the Ranbir Canal expansion and agricultural, canal that they have. That they're also thinking of doubling that. That some are saying, could reduce, 20% loss of water that is coming into Pakistan, which is a significant number, right? So, do you think that, at what point does this become something that the international community has to take action on? Especially, you mentioned international peace and security. This already becomes that thing because it crosses India's borders. It is now an international matter because it's affecting Pakistan. And 260 million people are dependent on these reserves.
Well, I think we need to push the international players to recognize the gravity of the situation on ground in the subcontinent in the context of water. There are 2 or 3 ways for doing that. The first way would be obviously going straight to the UN Security Council and continuously documenting your protest at every move that they do, every announcement that they make, every contract that they execute for construction of the tunnel or a pondage or a project. We need to protest formally, both bilaterally, in writing to Indian side, so we are able to document our continuous protest. And as you know, under international law, a continuing objection and raising of it and consistency to raise objection has a legal impact.
Absolutely.
And omission to do that also has a legal impact.
That's true.
So therefore, I strongly suggest continuously objecting to every step that they are doing, and then submitting those objections to the UN Security Council, to the Office of the UN Secretary General, to appropriate committees in the UN General Assembly where we have much wider audience and greater flexibility. And to me, this can fit into agenda item of 6th committee and several other committees which are there, including the human rights agenda item in Geneva forums. So that is one area. The second suggestion would be to reach out to well-known influential capitals and to inform them, especially the P5 countries who are the custodians of global peace and order, because this issue does not involve any one of them. So therefore, they may be politically more inclined to take cognizance of this. The third option that I examine is that a coalition of subcontinents, countries which are likely to be affected in any way by the position that India takes as an upper riparian or the state practice that we have in this region. Because India's water issues are both with its own upper riparian, which is China.
China, absolutely.
With its own lower riparian, like Pakistan and Bangladesh. Mm-hmm. And of course, Nepal, it gets associated with that. So I think there is a common issue, common state practice, common principles that these countries can identify and take a uniform position. And as I said, the upper riparian of India now has now, as we say, locus standi in the entire water issues. Whether you make it a party at a subsequent stage when there is a possibility of opening negotiations for amendments or an additional protocol to a treaty, or even otherwise it has a stake because the water is flowing partially from the territory that China exercises control over. So China now has a stake in this.
Absolutely.
So I think these are some of the suggestions that one can think of. There are very many as well once you sit down on the dashboard, as we say. But if you remember, we as a team, Jamal inclusive, we worked good 10 years back on Indus Waters Treaty, and we exactly highlighted this. Yeah. When people thought that within the treaty framework, the water we are secure and all that, and we were saying, and I think we issued a booklet on this, and we said that the threat of making more pondages is completely outside the treaty framework. Treaty is an engineering treaty. It talks about the specifications of the pondage, engineering drawings that are to be submitted 6 months in advance. But whether that pondage should come up is not the question that is determined under the treaty.
I see.
That has to be taken outside the treaty bilaterally with Indians or international forums. So now we have to recognize that fact, that the political decision of making these pondages, the decision of making a tunnel is a political decision. You can object it's a material breach for the purposes of the treaty, but really it's outside the treaty, it's taken outside the treaty. We will do this. The treaty doesn't say so. In case of political leadership giving a manifesto, you have the right to do it. No. So it's outside the treaty decision making that is being done, that we are trying to read inside the treaty. So we should confine ourselves to engineering issues within the treaty, but outside the treaty issues like threat of suspension earlier, which is now converted into abeyance. And in 2016, we were looking at it that when Mr. Modi came to power and he set up a special task force to examine how to get rid of this treaty. And that's when we started warning that they are going into a different trajectory. And if you also remember, in 2019, perhaps, we had a legal diplomacy workshop.
Absolutely.
You and Jamal and several other team members were part of that, where we said, why can't we try and find a resolution between India and Pakistan, because most of the dispute have a legal dimension to it, whether it's IWT or Kashmir or Sir Creek or Siachen, law of territory and so on. So why not to create a group of lawyers on the Indian side and a group of lawyers on the Pakistani side, and they sit separately and look at the legal possibilities of resolving these issues. And then those possibilities and options could then move upward. And in that workshop, I insisted we should invite Indian High Commission a delegation. So we fought back with the powers to be, and they agreed. I said, let them come and sit.
Let them hear this.
And the Foreign Secretary became so interested.
Absolutely.
He came personally. I'll conduct. Attorney General Ashraf Saab became so interested. He came. So I think there could be ways to work around it, but obviously there's an enormous political hostility that is holding back even the right minds in India to come forward on ways to resolve this. This should not go on. This cannot go on.
Absolutely.
I mean, they've done what they could. We have responded. This can go on to the detriment of everyone. I think there should be a way to find constructive solutions on these issues. We give them access to Kabul, Central Asia. They give us access to Dhaka and so on, Nepal. And this region could convert itself in a venue of economic excellence.
Absolutely. So you've spoken about the potential for peace and how that could work. But we also have to look at the alternative, right? And in fact, Pakistan's National Security Committee has said that using water in the way that India has done, stopping it for Pakistan would be considered an act of war, and we would respond to that. Bilawal Bhutto. So this is across party lines, right? Bilawal Bhutto himself, he said that the way India is using water is going to be considered an act of war in Pakistan. Field Marshal Asim Munir Saab, he himself said that if India is to do these, we will target dams. Now, sir, under international humanitarian law, we know there's a taboo against targeting dams or nuclear facilities because they can release dangerous objects. But in this particular context, the alternative is that Pakistan is deprived of a major portion of its water. Would there be a certain level of legality to these things? How can Pakistan go about this if it had to, as a last resort?
Yeah, I agree. As lawyers, we should rather hope we don't come to this point. I think it's no one's interest, whether including people in Pakistan and people in India, that we come to such kinetic, strong measures where we have to destroy and use force to do that. The rhetoric on the political side is perfectly understandable, because no political party can survive if it does not take this position.
Okay.
It is forced to. That's what people's sentiment is. How can someone stop our water?
Exactly.
How dare someone stop our water? We have a right, not only since 1947, for the last thousands of years. This region, this civilization has a right to receive water. The Harappa, Mohenjo-daro and all that are the footprints of people who have been here before, of different religions, different civilizations. They have been receiving water.
The civilization is named after the river system, right?
So you are trying to temper with something that has been providing benefit to a downstream, low riparian communities, countries, and so on. No one will accept it. So whether it's Bilawal Bhutto, whether it is PTI, or whether it is PMLN, they have to say we will react. There is no choice.
Absolutely.
And then commander or field marshal has to say, and anybody in the government has no choice but to say we will strike. We just cannot take it lying low. But then what will be that particular moment of that countermeasure of kinetic nature? That is something I think that debates needs to open up in Pakistan. While we talk about peace, while we talk of legal diplomacy, general diplomacy, but at the same time, and which should be the venue of this discussion? To me, it should be the parliament. People's representative, people who are likely to be affected by deprivation of water, people who are threatened situation of famine around them, they should step forward and ask their representatives in the parliament, sit together, discuss when will that red line be crossed. Create a committee, have a joint session, create markers which is available, announced to international community. If this happens, action A. If this happens, action B. If this happens, action C. Initially, it could be non-coercive measures, and then it could move on up to a coercive measure. So it is a proper notice given to international community by the representatives of Pakistan that we are left with no choice. So either you take cognizance of this region's issue in the UN or informally through P5 diplomacy, whatever you want to do it, failing which we are left with no choice. And if you know, in the International Court of Justice opinion relating to nuclear weapons in 1996, they were criticized for leaving a window of extreme circumstances of self-defense open, where they said you shouldn't use the nuclear weapons. That's what the International Court of Justice said. It was a legal opinion from General Assembly was seeking, and WHO, I guess. And they said, we want to know if the use and retention of nuclear weapons
can
are
ever be
against
lawful.
international law or IHL, or words to that effect. And it came just to this conclusion: the use of the nuclear weapon is against IHL, against international humanitarian law, because it is in violation of the principle of distinction.
Absolutely.
And if you notice, go through the fatwa in Iran, the religious fatwa, that is also based on the lack of distinction principle again.
I see. That's very interesting.
So ICJ was saying that you shouldn't use it. But they said somewhere in para 2F, if I recollect, that but we cannot decisively say if its use in extreme circumstance of self-defense is justified or not.
I see.
So they held back. But there could be a situation where you have to use. Now, I'm certainly not an advocate for use of nuclear weapon, and no one should be. Short of that, again, kinetic uses, the use of, in case it comes up, then your other platforms that can be used to degrade that potential, as we say in a technical jargon, to hold water. And that degradation can be done by several means. And I wouldn't say we come to that point where we think of using an extreme measure. But we need to alert the international community based on the parliamentary deliberation that this is what the people of Pakistan think, and this is what the Parliament of Pakistan has come to a consensus. And therefore, while on one hand we say we are open to talks, we don't mind, we are open to talks, we have tried to negotiate issues between Iran and US. So we are, as a country which believes in Pacific settlement of dispute, but at the same time we need to also tell what is that we can do.
So that's very helpful. Sir, finally, I just want to discuss the role that the World Bank has played throughout this. It has been almost a guarantor or a third party that has been part of the Indus Waters Treaty traditionally. It also, after India's intransigence in this issue, it withdrew and suspended the application of the dispute resolution mechanisms under the treaty as well for some time, but then it restarted those. Do you think it has a role play going forward?
I think I should clarify the role of World Bank in IWT. I would say they are a political party to it, but they are not a legal party to it.
All right.
And politically, people assume they are there, and since they nominate experts and so on, so they continue to remain involved with the treaty framework. And since they were the pioneers, they brought people together. But I doubt if we can treat them as a legal party to a treaty itself. It's between India and Pakistan. But still, they have a role of of a political clout in terms of, or goodwill standing, being the founders and being the initiators of this treaty between the two countries. And pursuant to that, they are playing that role.
Absolutely.
I mean, if I recollect the World Bank chairman's press briefing or something, in which he actually said that this treaty, in our understanding, cannot be held in abeyance.
I see.
Now, when he says that, it's not coming from him. It's a policy position which has been cleared, vetted by the legal team of the World Bank. Their international lawyers have examined that before the bank's president gives this formulation, which looks very simple, one sentence, two sentence, they cannot do that in our view. Behind that is an hours of work by a group of international lawyers assessing everything and then giving this brief to the president saying, so you can say that. So I think they've said it. They've said it that holding in abeyance per se is in disregard of the treaty framework. So their support, which is based again on a legal principled position, is aligned with that of Pakistan. So I don't think so we can expect anything more from them.
Okay.
I think we, as I said, we 5 countries have a role to play, and the international organizations have a role to play, and that's where we are.
Absolutely. Mr. Anver Sufi, thank you so much for joining me. Thank you, sir.
Pleasure is mine.
Ladies and gentlemen, that's all we have for today. Thank you so much for joining us.